Okay, welcome back to Interfex Live. Okay, our next session, we're going to be discussing how to protect your IP, in particular when you're going out and you're looking in a CMO environment. Over the last couple of days, we've talked about this quite a bit. So joining us today is David Wigley, Bill Warren, and they're both from the law firm of Sutherland. We're going to be talking about a couple of strategies here. Anyway, the reason that this came about, I asked, when I was early on in my career, we were out looking for various technologies, guys, and one of the things that my boss, he thought it was, at the time, I guess he considered it sage advice. I've cleaned it up for this presentation, but he said, the more you shop this stuff around, the more you give your competition the heads up. And I didn't think much about it. And like I said to you, David, I was surprised about 6 months after our launch, our competition came out with a very similar product. So apparently he was right along. So that's the reason we want to get into this. So how do I protect it how do I protect this conversation, guys? So David, where do you start off?
Yeah, that's, your boss gave you some very sage advice for us, indeed. And it's premised upon the fact that you do have some IP that needs protecting, and it needs protecting early on. And so we're going to be talking a little bit about patents, and we're going to be talking about agreements as well. And those are two main ways that we're going to be protecting these. So one of the first things that I would say that we want to do, that you want to do, is if you're whatever your situation, if you're a small pharmaceutical company, a virtual pharma company, you're getting ready to engage with CMO on some aspect of development or formulation or whatever, you need to be very careful about auditing basically what you have in your technology transfer package that you're going to be delivering to the CMO. You do have IP in there. It may be patentable IP. It may be something that you are going to have to protect with trade secrets, but you need to really know what it is that you've got and be ready to protect that. So if, for example, you are licensing some technology, perhaps an API or something from a university or another company, perhaps that's already protected by patents, but there may be other aspects that are not. So you need to do an analysis and an evaluation. Perhaps that would involve a patentability analysis. If you identify something that you think might be patentable, perhaps some methodology, some platform, some formulation, that may be involved as well. So when it comes time to deciding about what to patent and how to patent, there's a couple of things that you should keep in mind. Number one, you want to figure out exactly where you are in the stage of development. Are you very, very early on where you've got a fundamental idea, you've got perhaps one or two compounds that you need protecting, but you still need a lot of development to do to really get this to where you want it to be. In a situation like that, it might be a perfect example of use of a provisional patent application. And so what this is, it allows someone to get a filing date, that very important filing date, protect whatever it is that they include in that provisional patent application, and that gives, Russ, as you know, that gives you 1 full year to further develop that particular idea and that technology before you file the so-called non-provisional patent application that's eventually examined and will issue as a patent. So provisional, another advantage is, of course, that you could do that for a little bit less expense than you can a non-provisional. If you identify something that you want protected, you could get something on file for, $5,000 to $7,000 or $8,000. When it's time to convert that into a real non-provisional application in the U.S., that might be $10,000 to $15,000 or maybe $20,000. It really depends upon the technology. One last thing to remember is that for the last couple of years now, the U.S. has gone to a first-to-file system, and that conforms U.S. patent law to what it is worldwide. So there's no substitute for getting something on file earlier rather than later.
Let me ask you this question, Bill. Mm-hmm. I mean, what this was, and let me kind of turn it around. We were shopping for a platform for our idea. In other words, it was we were looking for a modified release platform We weren't quite sure what we wanted, but they were, let's say there was 3 out there. And, I guess what I'm saying is we walked in and there was, other than the concept of what we wanted, it wasn't a whole lot more. I mean, it wasn't a tech transfer package. We didn't do any of the real development, although we were, we owned the innovator compound. Okay,
Right.
so isn't that sort of more like a internal trade secret that we're trying to come up with? Seems like that's a little softer to protect, isn't it?
Yeah, certainly, yes. A trade secret is going to be a lot more difficult to maintain and therefore protect, but in the scenario you just laid out, you might not even have a secret to protect yet if you don't know what the platform is you're going to use. So in that case, you've got a molecule, you know an indication, and you're looking for a delivery platform. Most often, that's going to be provided to you by a CMO or another formulation expert that's going to have protected that platform themselves. So you would essentially be licensing it by virtue of buying the formulated finished product from them. So they're going to have filed the patents, as David mentioned early on, in their whole development scheme across a broad use of different API. And as far as what the innovator of the individual compound needs to keep in mind, though, is whether your basic combination, your formulation of excipients, your new chemical entity itself are protected, as well as perhaps if you've got a new indication or a new dosage formulation or mode of delivery, you want to be filing patents yourself on that before you approach the CMO for a particular finished product slow release formulation. So it might be helpful to kind of give an overview, a little bit of what kinds of things are patentable, a little bit more about what needs to qualify, what are the rules for patenting something, and you're going to need to have something that you can demonstrate to the patent office that's new, of course, that is non-obvious to one of ordinary skill in the art, and something that is qualifies as patent eligible subject matter, and that's been the subject of a lot of debate recently, particularly for compositions of naturally occurring products. So, and as well as genes, some biopharmaceuticals are also going to be subject to heightened scrutiny on whether they qualify for patentable subject matter. But generally speaking, broad categories of what's patentable are the new chemical entities, the formulations, methods, or routes of synthesis, new indications, new methods of purification, polymorphs, and of course all of the machines that go into putting those together. You can of course patent all the articles of manufacture. As well as the systems of analysis to make sure that what you've got at the end is what you want. If it's a highly technical spec, you can frequently patent that testing method to keep the competition out of producing it the same way you are or your CMO is.
In that case, what you patent is the specification, or you patent the method, or what do you patent in that case?
Yeah, so if you're...
You don't understand what I'm saying. I mean,
Yes,
I've seen it where people patent a specification which is exclusionary. In other words, this is my, and that you, that's the operating space. You know?
Right, if you are the first one to isolate a particular API to a certain purity, then you can get a patent on that purified state. And anybody replicating the molecule and that isolation as defined in your patent is, even if they're approaching it from a different manufacturing route, would still be infringing. So that's a great way to block competition.
I was going to ask, the next question was what to patent, but let me ask you this. One of the things, I mean, there's obviously in our business, we get approached by a lot of people, and most of the time is, well, can you figure out a way around it, perish the thought, but that these things do exist. But there's certain things which are totally airtight. So, I mean, to me, there's different types of patents. Like, for example, is composition of matter patent. How does this stuff break down, David?
Yeah, they're absolutely. They're composition of matter patents, so that would include things like the compound itself, the API itself. It includes, as Bill mentioned, a certain purity level or a certain enantiomer or optical isomer or things like that. Even polymorphs are subject to patentability. So you can get a patent on Form 1, Form 2 of an API. And so think of the power of that, Russ. If you've discovered that first and that has come about by a non-obvious way, you can prevent anyone from producing that API even by a totally different method if there's some of that polymorph in there. So these are very powerful things. You can also get patents on the route of synthesis. And very often, we work with clients who come to us and say, well, this compound, this API now is off patent, and yet the preferred route of synthesis is still patented. Now, how can I still make this compound? And so we will work with them, advise them on, perhaps other routes of synthesis, do a quick analysis of whether that route of synthesis would be infringing any patents that are out there. So things like that are very valuable, I think. As Bill mentioned too, things like, all the methods of treatments and combination therapies and all kinds of things. Just about anything that you can imagine would fall under patentable subject matter.
Let me ask you just a question. I mean, what we've run across where physicians will come to us and they'll have an old compound, but they have a new treatment, and they'll get a patent on that. I mean, where does that kind of fall in defensibility? I mean,
Sure, so you find new uses of known compounds or second medical use of a known compound, and if the indication, the disease is different, or if the dosage is different, then you can patent that as a new method of use, a method of treatment claim. And those are Orange Book listable patents, so they hold a lot of value, and of course that's the basis. Getting a patent is often the basis for the financing needed to get a new FDA clearance for the new medical use. And so absolutely you want to look at if the molecule is known, whether you can patent a new use.
Well, it seemed to me that follows the A plus B equals C. Absolutely. To me, the way, and again, the other sage advice was, a patent should be pretty straightforward. In other words, if you use that drug with this polymer and you got that result, that's the patent. In other words, you can't get to it if you don't use A and B. If you use A and C, it ain't working. What I'm trying to, it's the same concept. I mean, that's a pretty airtight approach then.
Well, it is, and you want your patents to be clear, but again, just because something was known before and you've got a new use, that is a solid legal patent. But just as you can try to design around a manufacturing method, an alternative to get around patents, if you want to compete in that space, is to try to invalidate the patent. And so there may be a piece of prior art, there may be a reference that was published before the patent was filed that the patent examiner didn't find, that nobody was aware of, but if you're able to obtain that, then you can challenge the patent. And if you're looking at a generic product, that's the route to making a paragraph 4 certification to get your 180 days exclusivity.
I'm not, this wasn't going to be a discussion about how do I circumvent something. I think what I'm saying is, I think people have to understand that there's certain patents which, let's face it, some of them are pretty flimsy.
Yes.
So the question really comes, other than getting a number in your name on a patent, that's about it. And then there's the kind that really makes it a bulletproof product. I think that's where I was going at. So having said all of that, so the question really comes back to is, when you go out to, so the question is, do you ask what to patent before you talk to the CMO? Or, so I've done this technical inventory. I've decided what's a secret or a trade secret, or what is a technology or something unique. Could be something in the drug substance. So I've done this inventory, then I have this conversation. So what do I do next to protect myself?
Yeah. You certainly want to do that before you, disclose any of your technology to the CMO. You want to really take a hard look, seek some advice from someone who's in the business to say, here's what I've got. What do you see that's patentable? And sometimes you can do a fairly cost-effective patentability analysis on, which includes a search of the prior art, just an idea of what's out there, what's been patented, and get some advice on what someone sees who's a patent specialist that might be protectable by patent there. So that's one side of the coin, and what we're going to hopefully get to in just a moment, Russ, is that the other side of that is that you must assume that during the technology transfer, during the work between, pharmaceutical company and CMO, there is going to be IP that's going to be developed. It will arise. There's going to be something that's going to be a nuance that's going to be required to make this process to work, to get this new route of synthesis. You have to anticipate that there's going to be new patentable subject matter. And so now you have to really think about and work in the agreement space on who is going to own that IP.
So in that case, I guess that all comes under selecting a CMO. So what do we look for there, Bill?
Yeah, so you want to look for a CMO with a good reputation, number one, because they vary with geography and they vary with the individuals that are running the organization. So you want to get good references. You want to make sure you're dealing with a reputable CMO that's going to respect at least the agreements that you enter into with them. You need to think about initially, am I hiring this CMO to simply do my bidding, to manufacture it in the way I'm telling them how to do it? Or do I need to engage them to help me invent a lot of that, right? Do I need, is there going to be a lot of collaboration and new inventions coming out of the agreement? So you want to start at least, once you've selected your CMO, with a confidential disclosure agreement. You want to make sure that agreement covers the term of the relationship, what's going to happen when that's over, and how it can be terminated earlier if necessary. You want to make sure you're going to get all your information and data back, that there is an obligation to return it, and that you as the contractor actually own the information that's being generated and the materials that you purchased for their manufacture. In some cases, you're going to want to prohibit reverse engineering if you're maybe supplying them with API from an outside source and you don't want them to know certain specs about it. That might be the case. You're going to want some mutual indemnifications for sure. So they're going to want to make sure that the API you're providing or telling them to manufacture is non-infringing on any third-party IP. And you're going to want indemnifications from them that the equipment and the processes that they use to manufacture for you are non-infringing.
So it's almost like it's a joint development between you and them. So having, so how do you manage that? So it's a...
Yeah, no, that's a great question. And in fact, we often see too late when someone will come to us with a simple non-disclosure agreement that has not really anticipated what's going to happen with intellectual property that's developed during this joint development project. And so we strongly recommend that, and we work with our clients to put in place not only a non-disclosure agreement, but a real joint development agreement that includes an IP agreement as well. And so, you need to understand that, as Bill pointed out, and I can add to that, it depends on what you're asking the CMO to do for you. Are you asking them to invent? Then you're going to anticipate that they're going to have some named inventors on some patents. But that doesn't necessarily mean that they are going to be the ones that own the patent. So inventorship is not really the same as ownership. Inventorship is a legal concept that has to be determined as you're writing the patent, who really conceived of the patent, the patented technology. Perhaps it's a route of synthesis or something like that. Ownership is something that you can control by the agreement itself. So, for example, I've contracted the CMO to develop an API. I've got an API and I've got a side chain that I know how to tinker with. I don't necessarily know which one is going to be the most active. So they will go in, they will develop the compound, they'll make the compound. It may require some different routes of synthesis. I'm expected as the person who took that technology to the CMO to be the owner of those compounds. But if, for example, and this is just an example, in the development there, if new broader routes of synthesis were developed that are applicable to a broader range of compounds, then the CMO might expect to say, well, I'd like to own that for, producing compounds that are not related to your compounds. And so all of that needs to be decided in agreement. If you're contracting the CMO to develop some non-infringing method of synthesis, for example, or a formulation, in that case, once again, you expect to own that route of synthesis and have the ownership of the patents that come from that. but it may be strictly CMO inventors who are listed on the patent there. So, a lot of thought before you enter the agreement, making sure that's spelled out in the agreement before you really spill your guts on everything that you've got.
So, and that's all spelled out in the joint development agreement? Is that pretty much the way that works?
Yeah,
Yes.
absolutely. You want
Yep.
to anticipate as much as you can of who's going to have rights to the inventions that are made by either party, and who may have a grant back on licenses outside the scope of your intended use. So if it's a platform you're paying them to develop, you want them to assign the rights to you, but you might, in exchange for negotiating the price, say, okay, outside of the use with my molecule, I'll license it to you, and you can apply it in other fields for other API producers.
I guess the question really comes down to is where does the business part kind of end, and
Yes.
in other words, royalties or cost. I'm saying we're trying to figure out here who owns what.
Right.
All right. So I guess where I'm at is their rights to a patent is something which is a saleable commodity. Correct?
Sure.
Okay. So if I come to a guy and I ask him to put something into his platform that he has patent, right?
Right.
So I pay him for those rights. Okay, yeah, all right. But anything he develops on that platform unique to me belongs to us. Correct?
Yep.
Yeah, that's right,
Yep.
typically, and you can outline all of
Okay.
those rights, as David said, in the agreement.
Okay.
So the only thing that's not changeable is inventorship. So if their guys or your guys come up with the next idea, the improvement, then they need to be a named inventor, but you can, in advance, agree on who's going to control the rights for those scenarios.
Yeah.
All right, so David, inventor, owner.
Yeah.
So
Yeah, what's the
where's
difference?
the bang for the buck there?
Yeah. The bang for the buck is really in the, controlling the rights to the IP, the ownership. Now, in inventorship, really, the touchstone of inventorship is conception of the idea. So, in your example, I may say I've got a drug that I would like to put into a soft gel formulation or something like that. I go to the soft gel companies that are specialists in knowing how to do that. So I'm using their technology. They're using their technology to put my API into that particular formulation. So in that case, they're the inventors. They're the owners of that technology, but they're going to allow me to use it. I will be licensing that, and that's part of what they're doing. For me to be able to, to sell my drug in their particular platform. So a lot of times we see people who are so tied up about the difference between ownership and inventorship. So it may very well be that the other party of the agreement is they're going to be the ones who actually are the listed inventors on the face of the patent, but that patent will be assigned to you because you're the one who paid for that to be developed. And in that case, the inventorship is really irrelevant. You control what happens to that. You control the licenses of that and who uses it and who does not use it.
What other sorts of obviously it sounds to me like doing your homework, due diligence. What else can I do here?
Yeah.
What else can I do as an owner?
Yeah, I think from the IP point of view, you need to do your own homework beyond filing patents yourself. Hopefully you've got something new that you can use to keep the competition out. But on the other side of that coin, you need to make sure you're not infringing any other third-party patents. So you could have an improvement, you could have a slightly different molecule or a new method of use, but you should search on your own or engage an IP attorney to make sure there are no third-party patents that are going to come back and bite you maybe halfway down your path to development, or worse, once you're in the market, and then somebody says, hey, you owe me back royalties because everything you've done to this point has been infringing. And so, you can do a pretty good overview of what third-party patents are going to be relevant in the $5,000 to $10,000 range, the searching, the initial analysis. If you need to really drill down on some of those patents, if there's some problems there and you need to design around them, or you need to blow right through them and invalidate them because that's a roadblock for you, that's going to be significantly more work. That's probably, you know, in the $10,000 to $25,000 range to come up with a freedom to operate opinion over a set of problem patents.
And freedom to operate, that means?
That means you are free to use your invention without being liable for infringement of somebody else's patent. So you're free to operate without liability for infringement.
Yeah,
When does this search take place? Is this all part of the homework exercise?
Mm-hmm. It takes place at various stages, but in a sense, that's really, it dovetails with this indemnification. So, you know, before I'm going to indemnify someone for the technology of mine that they are using, like a CMO, I'm going to make sure that my technology and the use of that technology doesn't infringe someone else's patents. So sometimes that's done in a sense in parallel with the audit of the technology transfer. You know, the closer we are to defining exactly what that technology is going to look like, and that might be before we actually do the tech transfer or after, if things are being developed by the CMO. The closer we are to really defining that, then that's when we really need to drill down and focus on that freedom to operate, to make sure that you know, myself or the person that I'm indemnifying, they can use that technology without infringing a patent that's out there.
You know, we should point out too, Russ, that once you identify these third-party patents that are potentially roadblocks, you may want to design around it, you may want to invalidate it. Another option is to talk to the owner and license it, because being the owner, can control through a license of that third-party patent can be a great asset to you for listing in the Orange Book yourself, or just preventing competition generally. If it's a method of manufacture that's a roadblock and it's not listable, then you can at least use that patent rather than try and take it down.
Mm-hmm. Yeah, again, it gets back to what probably one of the worst experiences I think I had shared with you guys was they used a specific polymer with a specific drug.
Wow.
I couldn't get where I wanted to be without using that polymer, so we negotiated rights.
Yep.
It's amazing how the price goes up when you need it.
Yeah.
You know?
Yeah. So the earlier you identify those, the better. If you're, you know, T-minus 1 day to launch of your new product, the price is going to go way up.
Yep. So, okay, let's just, while we're on that topic, okay, let's say I suspect I've been had. What do I do now?
Yeah, that's a great question, and there again, you need to go back, and I would say the first thing you need to do is to seek some advice, get someone on board, tell them about what you suspect, but very quickly take a good look at the actual technology that you did transfer. Make sure that that's very well documented. Go back and take a look at agreements, review contractual obligations that the other party may have signed on to, review your contractual obligations. See if you can identify things that were not done properly there. If perhaps some IP was not returned to you, if you suspect copying of the IP, that kind of thing. And then, as I say, early on, seek some legal advice. This is one of those things where, as you well know, a little bit of an ounce of prevention, a little bit of money up front will save you an enormous amount down the road. So the sooner you get some legal advice on this, the better. The devil's in the details here on really what's out there, what you've transferred.
I have to admit, it always is, and I think in a lot of cases people miss that opportunity, especially in these days of collaboration. I think, and let me just, and I think one of the other things I see that is probably mishandled is everybody thinks they can search. My understanding is patent searching is a pretty specialized area, is it not?
Yeah, most definitely it is. I think you can do some initial searching on your own. There are a lot of great search engines out there. The patent office itself has a fairly reliable system for searching. Google has got a great search engine for patents as well. So that's sort of your first least expensive way to find the problems, but I wouldn't stop there. I think you do that very efficiently yourself, and then you engage probably a patent attorney to do that. We frequently farm out or subcontract the searching itself, so there's a whole universe of patent search or prior art search firms out there, and that's all they do. They have great contracts on the databases that they're searching through, and they're experts at just looking. So that's something that's a task that even the patent attorney typically will subcontract just based on efficiency.
But if I haven't filed a provisional patent and I haven't filed anything, it's all hearsay. I mean, somebody can't show up on my doorstep and say, well, you know, I thought, no. But I think just to be clear, so when you say prior art, it's prior art that has been filed as provisional, or prior art that was filed, for example, can somebody make a case on something that was written in a technical journal?
Absolutely, yeah. So when you're looking at scoping out your own patentability, absolutely you want to look at technical journals, publications, poster presentations at conferences are prior art. So any disclosure that was made publicly without an obligation of confidentiality can be used against an applicant for a patent. The same thing, of course, for commercial sales. Even if it was a secret commercial sale for profit, that's prior art that can defeat an attempt to get a patent after that fact.
Well, it sounds to me, before we get into a patent fight, it's a lot better to do your homework. It seems to be a lot more economic, if nothing else.
Yeah, certainly a lot more economical, you bet.
And, you know, the end around a patent, I think in a lot of cases you wound up with something that's not really the best, because it's only, you know, that's been my experience. An end run usually gets you just that, you know.
Yeah, if you're going to try to not only design around somebody else's patent, but then try to patent your design around, that's going to be a very narrow scope of a claim there. And it might be valuable for somebody that's trying to copy you. It depends, you know, it may be that you're getting patent on the cheapest way to make the new formulation. And that can be extremely economically valuable, even though it's a narrow patent on a route of synthesis. If that's the most economical way to make something, then you're still going to be the one that wins in the market.
So, just bringing around to where we began, it sounds to me like, you know, you got to know the guy you're going to. You have to have, even if he's your buddy, it sounds to me like you have to be pretty much upfront with what you're going to agree and not agree. I'm going to do a tech transfer, but before I go and talk to this guy, I'm going to have the gee whiz, I should have filed a provisional on this. And if I hadn't, I shouldn't be talking to people.
Absolutely.
Yes,
even if you've got a CDA in place, you need to have documented and filed your at least a provisional patent before that.
Now, how long does something like that take to file a provisional? I mean, let's just say after, in our industry, everything is yesterday. Right. You know, so
Yeah,
just give me a sense of that.
You can file a provisional in a couple of days to a couple of weeks. I mean, it just depends how much information is provided to the patent attorney to build upon, to state a claim, potentially do a little bit of searching and understand what is new about that disclosure, and you can turn that around in, you know, just a matter of days or short weeks.
And what do you get as a result of that? You get a number and you get into the system. That's
You do.
it.
You get into the system, you get a provisional patent application. That patent application gives you that all-important filing date, and if that filing date predates your technology transfer, then you know you've got that you've got that date, and you can use that date as the date that's going to be the effective filing date of the real application that's going to be the non-provisional application that's going to be examined and which will eventually issue as a real patent. And so that's tremendous protection. One thing I want to mention as well is make sure that you're ready for that, because when you file that provisional application and you file your non-provisional application, basically 18 months from that first filing date, that provisional filing date, your patent application will publish the non-provisional that you filed. It will publish and it will be available to everyone that's out there. Your protection is that you've got that filing date 18 months earlier. But everyone is going to know what you're doing and what you're up to within 18 months of that filing. So it's, you know, you have to stay on top of it. You have to make sure, but you're exactly right, Russ. File early, and if you have, you know, updates and advances and improvements, file again. File on those improvements.
And the improvements now, I understand, take various forms. I mean, we could do, what do they call that? After your actual patent, there's a change in...
Like a CIP
Yeah,
or
how's that work?
you can file, for example, what's called a continuation application or a continuation in part application. A continuation in part will add new information to an older application, and so that means your older application won't be prior art against your new technology. So that's very important. That's an important tool sometimes to use. It's important to remember that any technology really has a layer of patent protection around it. Usually not just one patent or two, but sometimes just a layer of technology. Some broader patents, some more narrow, some more embodiments of the most important commercial embodiment, and some broader in terms that would be more on the high level idea and how you've converted that into a real embodiment. So it takes some thought, it takes some seeking professional advice, and getting things on file before you really disclose it.
Well, I appreciate your time, gentlemen. We're coming back to the close on this one. I think it's important for people. I hope that everybody's picked up on what to do. I mean, for me, the CDA is always the go-to document that people send out, but I'm hearing that to protect yourself in the long stretch, part of that protection should be a provisional if necessary, if at the very least.
Yeah.
But you got to be ready to act upon the provisional.
Yes,
When that thing goes public, everybody's going to see it anyway.
Mm-hmm.
Correct?
Yeah. And consider in your joint development agreement, including inventorship and provisions for ownership of the next generation of ideas that are going to come out of that collaboration.
Right. Well, I want to say thank you, David, Bill. Thank you very much. That
Thank you,
takes care
Russ.
of this section of our Interflex Live. Thank you very much.
Thank you.